Hi, I'm Rachel Griffin. One of the key concepts in any financial planning is the residency and domicile status of your client. Today, I'm going to focus on UK domicile. I will briefly consider the following types of domicile: domicile of origin, dependency and choice, as well as deemed domicile, and the changes to non-domicile spouses or civil partners which came into effect in April 2013. This is the domicile that is acquired at birth. It is normally taken from your father. However, if parents are unmarried or a child is born after the father's death, then the mother's domicile is normally acquired. Under general law, you will retain your domicile of origin until a different domicile is acquired. A child's domicile will follow the person on whom they are legally dependent. So if the domicile of that person changes, the child's domicile will change in place of the domicile of origin. An individual is able to try and acquire a new domicile, a domicile of choice, by settling in a new country with the intention of living there permanently. However, it is very difficult to acquire a new domicile. There are no fixed rules or requirements, and the burden of proof falls on the individual to prove they have acquired a new domicile. The status of an individual's domicile has to be considered on the facts of the individual case. For inheritance tax purposes, there is also a concept of deemed domicile. This means that even if you are not domiciled in the UK, under general law, an individual would be treated as domiciled in the UK at the time of a transfer of assets if that individual were domiciled in the UK within the 3 years immediately before the transfer, or resident in the UK in at least 17 of the 20 income tax years of assessment ending with the year in which they make a transfer. The Finance Act 2013 introduced legislation which increased the lifetime limit on the value of assets that can be transferred IHT-free between UK domicile and non-UK domicile spouses or civil partners, from £55,000 to the applicable nil rate band. A new election regime has also been introduced, which allows non-UK domicile spouses or civil partners with UK domicile spouses to elect to be treated as UK domicile for inheritance tax purposes. Let's consider a simple example and the implications of making an election. Elizabeth is a non-UK domicile and is married to Andrew, who is UK domicile. Andrew dies and leaves his whole estate totalling £1 million to his wife. Whilst £325,000 would be IHT free, the additional £675,000 would be subject to IHT. Elizabeth is able to make an election up to 2 years after Andrew's death. Once the election is made, it takes effect from the date of death of the deceased spouse or civil partner. Therefore, in this example, the whole of Andrew's estate will pass to Elizabeth IHT free. This is because she will be classed as UK domicile from the date of Andrew's death. Careful consideration needs to be taken before making an election. We have briefly touched on some of the key concepts of domicile, which is a complex area, but it is an essential part of the financial planning process. Thank you for watching, and we look forward to sharing further technical knowledge to support your clients' financial planning over the coming months.